question. I mean, first, if I'm following you correctly, there is in the Scandinavian country no constitutional court of German type. So, what we call constitutional adjudication takes the form of the American model of judicial review. So it's not surprising that there is judicial review even if it's not written down in the Constitution, because in the United States it's not written down. The traditional idea that there is no judicial review in Scandinavian countries comes from ignorance, which is crass and relevant. It's like if you asked a student who read the American Constitution, is there a constitutional jurisdiction in the United States? And she would say no, because it's not written. So, but the second point is a clarification question. I don't understand what one can mean by legal rights. You made a distinction at some point between legal rights or civil and political rights. And I see the difference, which is classical in the United States, between political rights and other rights. By political rights, notably John Healey meant that the Supreme Court has to protect citizens' rights connected with the democratic process. Because democracy is not possible without rights of association, right of speak, right of vote. So there is a variety of rights which are inherently connected with the regular functioning of democracy. And then there are other rights, like abortion rights. Famously, Ely wrote a paper claiming that the Supreme Court in the United States has not to say anything about abortion. It's not inside its field of competencies, because abortion, prima facie, at least, and even if you think a bit more, has nothing to do with democracy, has nothing to do with voting. That's a different stuff, not like due process, in a sense, or freedom of religion. That has nothing to do with democracy. You may have a perfect democratic system where there is no religion. So that's what I understand. But what is the distinction between legal and non-legal rights? If you can.
Yes, it's a very important discussion that have been going on I think in the international human rights theories, as well as in national, specifically at national forum, and I guess Mats is very much acquainted with this discussion. The legal rights idea is a completely different approach from what you're comparing with in the States. And the legal rights approach is based on the idea that certain rights are, well, you know the idea of generational rights. The first generation and the second generation. The first generation is the classical freedom rights that we have initially incorporated into the constitutions. I mean, these are mainly civil and political rights, as we call them today. The freedom of speech, of course, the freedom from all kinds of interference from the authorities in their own rights, which means they're also called negative rights. They require nothing but that state authorities they only just have to, they don't have to interfere. It means that they are secured. It means, well, it's connected to the natural rights. You're born with them, you're not granted the rights. If you're just left alone by the authorities, you will enjoy all these rights. It means they are immediate. And that also means that they are considered to be justiciable by the court. It means that they can confirm in a concrete case if the authorities have overstepped their duty that they should not interfere. So either they've been interfering or they've not been. So it's either or. It's easy to establish whether this has been violated. Whereas the economic and social rights, like I said before, they've been considered to be something which must be guaranteed progressively, depending on the financial sources of the state. So having a court decision on how to resolve whether a right is violated in an individual case is considered to be of a non-judicial issue, because this is depending on how the state is prioritizing in their budget. And so just what I said before, these are maybe what the political, the legislator should be the only one dealing with this. So this is the idea. The legal rights, the court can confirm if they have been violated, whereas the other rights are not justiciable in the sense that the court cannot decide. This will be happening progressively. The courts are overstepping their mandate if they start evaluating if it was done correctly.
I have another question. In countries where there is no constitutional court of the German type, often the courts exercise what I call normative power. People speak of legislative power in general, through statutory interpretation. So you don't need, if you want to change a statute, you don't need to say it's unconstitutional. You may say the statute is unclear, and we, the court, we are not doing anything concerning the constitution. We are a shy court. We are just telling you what does it mean. There are countries where laws are unclear or badly written. Italy is a very good case in point. We don't have a Conseil d'Etat writing the laws. Laws are written by politicians, so you can imagine it's a disaster. They're not written by legal experts like in France. Yeah. So the court says, well, that's okay, it's constitutional, we don't care about the constitution, but we tell you what the law means. And that's a clear exercise of legislative, normative power, without bothering with the constitution. What about this type of statutory interpretation in
it
countries?
Be very, very narrowly used. The Icelandic courts are extremely cautious when it comes to something which is out of the scope of the exact dispute at stake. In some respect, they are similar to the Danish courts in that area, but even more restrictive on that. They would not say anything which is not entirely straight to the point in the dispute. In Norway, it's very different. I mean, the judges are actually expressing themselves differently in separate, what you call it in yes, exactly. But in the Icelandic system and partly in the Danish system, there's lots of restrictiveness to say anything beyond what's to the point. And that's related to the question that this court feel that they are not supposed to be legislating, because that is the general approach. Despite the fact that they are declaring something unconstitutional, they will try it only. I mean, I've not been telling you now that there are so hundreds of cases. I mean, we have so many cases about human rights and the Constitution. So the proportion, talking about like 13 judgments since 95, it's not compared to all the cases that we've had. But the court would be reluctant to do anything beyond what is strictly necessary for the solving the question. But one thing more, adding to this, if a legislation is very unclear, for example, penal law or whatever, then the court would usually say that it is not clear enough to impose obligations on an individual, and they might acquit an individual because the penal the penal provision is not clear enough, and that's also involved into the human rights part. Yes.
Yes. Thank you for your very clear and interesting presentation. But I have a question about the conclusion and this concept of multi-constitutional system. I was wondering what it was meaning exactly. Is it that it is presupposing the existence of a super state kind of thing,
Mhm.
ruled with different constitution, but like in a federal
Mhm.
model or something.
Mhm.
Or is it this model of Union d'État-Nation, I mean nation-state union,
Mhm.
where you have sovereign constitutions added, but sovereign anyway.
Are you talking about now the last part I said
Yes.
about the European?
Yes, it's a conclusion by the
Yes,
European
yes. Well,
Commission.
exactly. That's what states may be in different positions in this respect, depending on their tradition, of course. They have to adjust their tradition to something which is coming from above, or what did you say? The shadow about the European Court of Human Rights.
Shadow constitution.
Yes, the shadow constitutional court. I mean, as we all know, the Strasbourg court is, clearly being in the judicial creativity. The states don't have any possibilities to object. They just have to, it's a binding judgment there, and they have to follow it. And the judiciary in the member state, of course, is under pressure and it's expected to take into account whether the European Convention on Human Rights has been violated. I don't know about France, but Iceland has had difficulties, especially with sovereignty, because it is once an international treaty, and it is not a supranational system. I mean, the European Convention initially never was supposed to be. It is a traditional treaty. It's different from the Union in this respect. So Iceland has had difficulties, and I mean the dualistic stage generally, because the European Convention is not given any primacy according to national law unless we make it somehow like they've done in Norway. They've given special supremacy, what do you call this? Primacy before general law. But I mean, there is great questions that we're dealing with in Iceland about the sovereignty of the states and the impact of the European Court of Human Rights. And what Iceland has done to react to this is what I was trying to say. It's like integrating the convention into the constitution. So we are not that much using the convention separately, but putting the convention as a part, assumed to be contained in the constitution. We use the constitution directly. So there is never a question about that we have to use the separate legislation about the European Convention on Human Rights. And in a way, I think it's a good way of solving this dilemma, but on the other hand, it's about being too dynamic about interpreting constitutions, but many countries are. I mean, our picture we have from the United States is actually what we're experiencing there. Yes?
My follow-up question to that, to say that the convention is sort of integrated into the constitution.
Mm-hmm.
Does that mean that you follow, for instance, the interpretation by Strasbourg very strictly, especially with it being
very good, yes.
Very careful judicial review system, or has there been a case where the Supreme Court or different courts have actually gone further or a different interpretation?
It's actually an obvious question that had to come because it's very much connected. Iceland doesn't have that many cases. We're only 300,000, so there are maybe 2 cases pending at the time, or both of them are declared inadmissible. But this is a very good point there, and that's the idea of how to apply the principles of the Strasbourg Court in cases against other countries. I read a good article by Mats Antonens recently about Klarhetsprincippet. What would you call it in English?
Well, you said manifest. It really is manifest in a way. Clarity of mind. It's slightly different, but
yes, but manifest and but the problem is. It's not entirely the same. But we had a problem recently in Iceland about case practice from Strasbourg, which the Icelandic courts did not consider clear enough. And this was actually different from development in Norway. It was about Protocol 7, Article 4, and then this in Eden principle, which is a classical provision of the European Convention, which has been interpreted really extended the field of application. I mean, it's now about, in our case, we were dealing with investigation from administrative body, which was finalized, and then the police started investigating it. So the question was, if a case is once investigated and it is finalized without indictment, doesn't mean that you can start another investigation. And this is really complicated because ne bis in idem initially was meant only to cover that you would not be sentenced twice for the same offense. But this has been stretched into all areas of administration, police investigation, and the problem there was whether a police investigation could, which had been discontinued, could start again. There was a lot of references to the European court practice in this case. The Icelandic Supreme Court said there very clearly, and it was a really detailed judgment, that the case law of the Strasbourg Court was not clear enough to be applied, which meant that if it wasn't clear, the legislator had to take the initiative to review the legislation because, well, this was about the tax. It was a tax question, and our whole system is based on a special Scandinavian model. Even though we have judgment in the Norwegian and Swedish courts, the Icelandic Supreme Court says this is such a huge issue at stake, and there's such an unclear indication from Strasbourg that this must be given to this is the role of the legislator to decide whether the system should be revised. It's not the role of the court. It's a very good example very different example from what we have in other judgments. So if it is unclear, they would not apply the rule, but if it is clear, they would apply the rule. But funny enough, they do not refer that much to the case practice, the judgments of Strasbourg Court, but they would interpret the Constitution of Iceland in a similar manner as the Strasbourg Court has done. So that's how they use it.
It's unclear, there is no law.
Sorry?
If it's unclear, there is no law.
If it's unclear, they would not set Icelandic law aside, at least. That's what they have confirmed.
Your intervention there.
Thank you.
Thank you.
Mats Josefsson.
Very well with the Icelandic paper as well, which is really interesting and shows the utility of comparative exercises, because not only does one find new material, but the perspectives, of course, change when you're dealing with your own system. And for me, definitely, it was very helpful in dealing with the. Well, as you all have gathered from now, there is no constitutional courts or no system for abstract review in Scandinavia, and then we share many things, but there are basically quite different traditions for judicial review.
How the way the program has gone. When should I like to the end?
13 traditions. So in Sweden, for instance, you had a system with administrative courts emerging, separate from the general court system. Judicial review of parliamentary legislation in the General Supreme Court in Sweden, as you now have shown, and particularly shall read his paper, there is a basis for it, but I just added as a kind of contextual point that it became a subject of very heated discussion in the 1950s, and Östen Undén, who was the long-term foreign minister of Sweden, who came from the left of the Socialist Party, the Social Democratic Party in Sweden, and then everyone on the left has a soft spot for him. But he had this very heated exchange with one of the Swedish administrative lawyers, who then said in an article there was constitutional review, and he then in Parliament said if a judge ever should set aside parliamentary legislation, that would be the basis for proceedings to fire the judge. He said in Parliament, and they wrote and they discussed, and that why I mention this is it gives the context. The context of the law in Sweden was that judicial review of legislation would be to protect property monarchy and establish positions and restrict the socialist regulatory state. So it was a matter for the right. And that is a very particular Swedish context. Östen, then, another reason why we all like him is because he was an Uppsala law professor and he dealt with property law in Uppsala, but he was also a constitutional thinker in a very restricted way when it comes to constitutional review of rights. The Norwegian constitutional discussion was different. And now today we have a revisionist scholarship which Jean-Louis has shown, which really comes about in the 1980s. And first of all, we established judicial review of administrative action in the 1820s, and then very shortly afterwards, in the 20s, 30s, you get the first decisions on review of legislation. And it is not so easy to see the starting point, and we disagree a bit. But for instance, there's a decision from the 1830s about some form of a penalty which is considered to be painful and in contravention of the prohibition against torture and painful treatment, and they just decide that provision cannot be applied. And it's a period where they do not give reasons, extensive reasons. So it's just then established, but it stops the application of that penalty from then on. Otherwise, I'll explain a bit more about the different aspects later on. In Denmark, as Jean-Louis said, you filled in, of course, administrative action reviewed in general courts, no special administrative courts as in Sweden. Same as the Norwegian system, but very, very deferential. You got other examples and fill that in, but as you say, there is this one decision which is then really about the competences in the constitutional system, not about rights. And we also had a tradition of in the Denmark, in the Danish tradition, of construing rights restrictively, so that, for instance, the freedom of expression, the way it was formulated in the convention, has been seen as primarily a provision against censorship and not a substantive freedom of expression protection, the way we would have very much in Sweden and in Norway, and of course in Iceland. Also mentioned that we have differences when it comes to form of judgment. The form of judgment is very different. Now, the Danish tradition was until quite recently that they didn't publish dissents. You know, they do publish dissents, but today they publish dissent, but it's quite short. And they even had a tradition for a long time that the junior judge and sometimes another judge wrote a comment on the case, which was published in the journal you mentioned, which is not completely alien. You know, you have similar traditions with the publication of case notes by a rapporteur general, rapporteur public, or somebody from the Conseil d'État. You know, so it's not completely alien, but it had a very particular. In the Nordic context, it stood out, very short judgments, and that remains today. So the discussions are very short. That also goes for the Swedish judgments. Their administrative court has a little shorter judgment than the administrative court in general, but they can have more and more extensive judgments on issues like the ones we are discussing. They do, I say extensive, by comparison extensive, but in historical perspective, but they're still brief. And in Sweden, you now have, in particular, in relation to some of the constitutional issues relating to the European Convention, you also have factions in the Supreme Court developing. So in the the General Supreme Court, you have a group of judges, two judges, one of them is currently the president, who took a view, which I will refer to later, about the requirement of manifest or clear breach. We have to discuss that a bit later because it's not absolutely clear what was meant by clear breach in the Swedish constitution. The degree of deference, Marlene Wind, Danish, she's professor in Copenhagen, isn't she? Or is it the Handelsskolen? Anyway, she's a professor in Copenhagen, and she has some really strong statements about the deference in the Danish system. She thinks it is extremely deferent. But I'll point to some of the aspects of that in a little while as well. So, foundations of review. So, the foundations of review are in the constitutional system. That's the argument. Hierarchy of norms. In a very Kelsenian way. No restrictions on the application of constitutional norms, the way one is used to from a French system. They have general application. They're not limited in time or any other sense. But it is then referred to as a not entirely obvious basis. So the way the academic doctrine treated this was already in the 1920s. In Norway, they said it was based on customary constitutional law. Customary constitutional law rule. Now, I'll come back to domestic constitutional amendment and international European law because that provides all foundations for review. Comparative law, as you mentioned, Lascaux, is extremely interesting. He, as would most constitutional lawyers at the time, he would take a broad comparative view. But in his case, he would then use that to propose to the Norwegian Supreme Court that the Norwegian Supreme Court should follow Marbury and Madison. Now, of course, that you can imagine could be very politically controversial in the big fights you would have in the Norwegian constitutional and political environment at the in the latter part of the 19th century, and the constitutional fight in Norway was about parliamentaries and the power of the executive in relation to the king, in relation to parliament, and in that context, it was by the left again considered as replacing or countering the emerging power of parliament over the executive and the decreasing power of the king or the executive by then review powers of the courts. Now, the revisionist theory is, of course, that Aschehoug basically gave a new justification to his comparative studies for what already was there. But that remains to some extent controversial. I'll come back to this in a little while as well. That's the